Good evening, everybody. My name is Niru Padmanabhan, and we are live with Public Allies with Jana Tsang. Jana's been on our platform many, many times, but before I introduce Jaina, just let me introduce myself. My name is Niru Padmanabhan. I am the Director of Engagement at Public Allies, and we are a nonprofit organization. And prior to COVID, we served the most vulnerable individuals in society. We held programming for seniors, low-income individuals, battered women, and we worked with many organizations to provide support programming. But during COVID, we weren't able to congregate and reach our regular audience. So we pivoted online and we became an educational platform. And now as things reopen, we are doing a hybrid form of services, but we still feel education is the great equalizer. And so we help individuals with different topics. And as COVID has happened to us, we've learned to pivot and embrace this new stuff. So as we get online, we bring you new topics every week with new discussions, roundtable discussions, webinars, interviews with amazing individuals, and we support our community through this and through our regular programming. So if you need any help, please reach out to us and we'll see where our programming can fit in for you. And thank you again, Jaina, for joining us. Let me just introduce Jaina really quickly. Jaina is a principal lawyer at Tsang Law with 11 years of practicing in family law, wills, and estate and planning. Jaina assists her clients in all things family law, from negotiating cohabitation agreements, marriage contracts, custody or separation agreements, to litigation, contentious separation, divorce proceedings. Jaina's also helps her clients in creating and updating their wills and powers of attorney documents to ensure that the proper decision makers and beneficiaries are in place. At the same time, she's working with her clients to tax on tax minimization strategies to reduce estate administration tax payable on debt. So please contact Jaina. Her information's in this webinar below. You can reach out to her and ask her some questions. If you have something that you really need to talk about, call her, see where she can fit in. And Jaina didn't mention she works with a lot of complex trauma. We've had many chats on it from males and females, from LGBTQ. Lots of trauma happens and you need a lawyer that understands you with that complexity. So Jaina, I can't say enough. Thank you so much for always coming on Public Allies. You're Public Allies' favorite for us. And you're always so generous with your time, and you always come back and you educate us and help us each and every time. So thank you so, so much. I met Jaina actually during COVID, so lucky me. And we actually met on Facebook. So I often get asked, where did you meet Jaina? I met her on Facebook, everybody. So you can meet amazing people online. Contact Jaina if you need any assistance with any of the things listed. Jaina, to you now.
Okay, thank you so much for that wonderful introduction. I don't know if I can quite live up to all of it, but I will give it a try. And thank you to all of you who may be tuning in or maybe watching this at a little bit later point in time. I'm going to start sharing my screen. And today, let me know if it's showing up properly there. Okay, great. Today, what I wanted to touch base on a little bit is on what happens when a relationship breaks down. Where do people go from there? Who do they need to talk to? What do they need to think about? This is not meant to be legal advice. This is meant to, give people who may be experiencing relationship issues some information that can help guide them to make the right decisions for themselves and to speak with the appropriate professionals. And so just see here. Okay, here we go. Again, I wanted to thank Public Allies for inviting me to join in on this today. It's always a pleasure speaking with their platform, and I'm very happy to participate. Okay, so when people are approaching the end of a relationship, so what are some of the ways that they can potentially resolve the issues that they're looking at? So the first little icon there you see is I've indicated counseling. And as a family law lawyer, I see a lot of, and I talk to a lot of people who are going through a very, difficult time in their relationship. Just because they're going through a difficult time doesn't necessarily mean that the relationship has to end. So if there is any way that the relationship can be salvaged, definitely counseling would be a great way to go. I would recommend counseling generally, whether people do decide to separate or do decide to remain in a relationship, because marriage counseling can be very beneficial for two people who are working through some difficulties. And, for someone who is, potentially ending a relationship, that, receiving personal counseling to help them work through the emotional side of things as they deal with, the other aspects in tandem, really does help them get through the difficult situation and coming out stronger on the other side. The next icon you see there is negotiation. So negotiation can be, the two people talking to each other and identifying, this is how they want to deal with their separation issues. It could also be the two people hiring lawyers to negotiate on their behalf. And if they are successful at coming to an agreement, that will be turned into a separation agreement that formalizes everything that they've talked about. The separation agreement is a legally binding contract, so that whatever is agreed to is enforceable at court. Another option is mediation. So with mediation, what happens is that the two people will go before a mediator. The mediator's job there is to help the two parties to communicate with each other, to try and break down any communication barriers, to help the two of them to identify what's important to each of them, to see if there is a way that they can, give a little on one particular issue and get something on another issue that is more important to them. The mediator is not there to make decisions for the two parties. They're there to try to help the two parties come to an agreement together. So with mediation, either party can walk away at any point in time. And that mediation does not necessarily mean that there is going to be a resolution at the end of the day, but mediation is definitely a great way to go if the two people are okay in terms of being able to communicate with each other. The next two options are arbitration and court. So arbitration is similar to going to court. We can think about it as kind of like going through court, but privately. And what I mean by that is that the arbitrator acts as the judge in this case. Both people will have to pay for the arbitrator's time. Whereas if you're going to court, you're not paying for the judge's time, you're not paying for the court clerk's time. And that's the difference between these two options. With arbitration, you would prepare for it like you were preparing for court. So more often than not, you would have a lawyer help you prepare your documents, to make submissions before the arbitrator renders a final decision on the issues that are being dealt with. And so in the arbitration process, you will likely have to pay your own lawyer as well as pay for the arbitrator's time. And so there's that added cost piece versus going to court, because again, when you're going to court, you're not paying for the judge's time, but you are paying for your lawyer's time. With arbitration, why it's sometimes preferred over court is because of the timelines that are involved. Arbitration is generally much faster than going through the court process. Now, with court and with the pandemic, the court timelines has definitely been negatively impacted. And, in terms of how long things take from the start, like, you're issuing an application to say, here are the things that I want out of the separation, to the end being the trial. So when you go before a trial judge for a final decision on whatever issues are outstanding at that time, that start to finish timeline, it can be anywhere, like, best case scenario would be, a year and a half. And it could be much longer than that, depending on what jurisdiction you're in. And so the arbitration versus court, if we're comparing the two, the arbitration piece does get you a much faster decision so that both parties are able to move on quicker. With court, again, we've talked about you don't pay for the judge's time, you pay for your lawyer's time to prepare for it. Why some people, for their matters, it does make sense to go to court sooner rather than later, is, if there is a lot of delay on the other side, that having the matter in court, you're now within the court framework, you have to work within the court timelines. And so there are timelines that have to be hit, there are things that need to be filed by certain dates, and otherwise then there are consequences to not doing this type of thing. And so that's why starting out at court sometimes is actually good to get a matter moving. That being said, of the cases that start out in court, I would say right now about 80% of cases that start in court does settle outside of court before they get to trial. Only about 20% of the cases get to trial, and that number obviously is an estimate. But and again, keeping in mind that if you are starting in court doesn't mean that you can't negotiate outside of court at any point in time. Okay, so when we are still thinking about the end of a relationship, here are some people that I definitely recommend for people who are considering ending a relationship or has just ended a relationship to get in touch with. So first and foremost, get in touch with a family law lawyer like myself, or another family law lawyer. A lot of family law lawyers do provide free initial consultations, and so at least you can speak with them, get some information before you decide on who you want to work with. Why I say it's important to speak with a family law lawyer first is you should know what you're entitled to, and before you make any decisions, before you come to any agreements with your spouse. And just because you speak with a lawyer, it doesn't mean that things have to get nasty, right? But get information, be informed before you start making decisions, especially around the bigger pieces around kids, property division, finances, that type of thing. The second group of people that it's definitely great to speak with is your financial advisor. If you don't have one, go out and find one to speak with, like Miro. Now that you are ending a relationship or you're approaching the end of a relationship, your finances and your financial future is going to look very different. And so you should speak with a financial advisor to see what your finances would look like, what you need to plan for, and how we would go about it. The third group of people is that are important in terms of getting in touch with is an accountant and potentially valuation experts, and that speaks more towards the property division side as well as the tax piece. So with the filing of income taxes, if you both own joint properties, if you own shares in a private corporation, so how do we value those shares, and what's the best way to minimize tax while still while we're still dealing with everything within the family law realm. Next is a wills and estates lawyer. And why that's important is because if you are separated but you're not yet divorced, and you, let's say, have a will that says that your spouse is still entitled to receive all of they're your primary beneficiary, they're going to get everything if you were to pass. So even though you're separated but you're not divorced, if you did pass away without updating your will, or if you didn't have a will at all, there's a possibility that your spouse, your estranged spouse, would receive everything from your estate in accordance with your will or in accordance with the law, and it's likely not something that you may want to happen. Last but not least, I've already touched on this, the importance of speaking with a counselor. And that's for your personal mental health and also potentially for your relationship, to see if there's any way that things can be salvaged. Okay, so if we have now moved on to dealing with, okay, we have separated. Now what are the things I need to think about? So the first group of topics I have here is all the child-related issues. So within the child-related issues, I would say there are three major categories. The first category is the major decision-making as related to the children. It's formally referred to as the custody, but there's now changes in wording in the legislation. We're now calling it major decision-making. What those major decisions are is anything in relation to education. So what schools will the kids go to? Is it public school? Is it private school? Is it Catholic school or other religious schools? If there are medical or dental decisions to be made, major medical or dental, and as well, what, excuse me, what religion or what culture the kids would be brought up in. The next big category is the time sharing piece. So with kids, and assuming they're under the age of 18 at this time, what is the regular schedule going to look like between the two parents? And in addition to the regular schedule, have we given consideration to the holidays? So, who's going to get March break, or is March break going to be divided equally? How is Christmas going to be handled? Thanksgiving, summer breaks, and all of these things. So having that additional schedule built in to reduce the amount of negotiating between the two parents that might be required. Last but not least, that's related to child-related issues, is the financial piece that's tied to it. So there is the piece of child support. Child support is based on the child support guidelines. So if the parent makes X dollars per year for 2 kids, then there's a corresponding table that tells you how much they have to pay for child support. So it's legislated. This child support amount is meant for to be dedicated for the children's daily living needs. So essentially food, clothing, and shelter. In addition to the child support piece, there's something called special and extraordinary expenses. These expenses are on top of what someone would pay for child support. So these expenses can include things like daycare, medical or dental expenses. So like, if there are prescriptions to be filled, if there are dental bills that are not covered by health insurance, then those would be shared by the parties. Extracurricular activities like sports, music, arts, and as well post-secondary education. So these are all extra and on top of regular child support, and these expenses are normally shared by the parents in accordance with their incomes. Okay, the next group of topics is the issue of spousal support. I'm just going to skip over this pretty quickly and move on to the property piece because we are quite limited on time today. The spousal support, this claim is available to both common law couples or married spouses. And keeping in mind that child support actually has priority over spousal support. There is no automatic set table like there is for child support. Any amount or duration of payment does depend on the specific circumstances of your case. So it can depend on how long you have been together, what roles each spouse has taken during the relationship. If one of them suffered a career or economic disadvantage as a result of the relationship. So, if someone moved across the country or moved from a different country to a new country for the other spouse, and as a result, they're not able to work or they don't have the same career opportunities, that increases the entitlement for support. Payments can be periodic, so paid on a monthly basis, or it can also be dealt with by a lump sum basis. Okay, last but not least is the property division issue. So this is a bit of a sticky issue. You see that there are 2 distinctions here. So for common law spouses, there's no automatic property entitlement. So the things that do get divided on that's more of a straightforward basis are things that are jointly owned. For things that are solely owned, but one spouse feels that maybe they are entitled to something, there is a possibility that they can bring an unjust enrichment claim against the other spouse to get something, against that, let's say, investment property that they helped or that they helped pay for. With respect to debts, each spouse is responsible for their own sole debts in their own names, and both are responsible for joint debts. The distinction here between common law spouses and married spouses is that for married spouses, there are automatic property entitlements. For equity, that accrues from the start, so from the date of marriage all the way until the date of separation. And this includes all assets, so whether it's in one person's name or in both people's names. There is special treatment of the matrimonial home. And if you have questions around this, I would encourage you to reach out to me or to speak with a family law lawyer about it. We are, again, quite limited on time today, but generally speaking, with the matrimonial home, regardless of, if it's in one person's sole name, the equity that's accrued from the date of marriage to date of separation is part of property division. So the other person is entitled to half of that. The calculation of how property is divided is essentially we look at each spouse's, and I'm just going to skip to the next page here because it does give an example. So we look at each spouse's equity. Equity is calculated by assets minus debts, and as well any pre-marriage assets. And that gives us an equity number for each spouse here. So we see in my example here, spouse A has an equity number of 300,000. Spouse B has an equity number of 620,000. So how we would calculate that property division in terms of who pays who what number is that spouse B, being the person who has the higher equity number, pays spouse A the difference between their two amounts. So it'd be 620,000 minus 300,000, which gives us a difference of 320,000. And spouse B will pay spouse A half of that difference, being 160,000, which would then equalize all of their property. So when we're talking about property division, we're not looking at going through each individual account to say, okay, this account, I owe you $40. So I'm going to transfer you $40. With this investment, you owe me 30,000. So you have to transfer me 30,000. We look at globally what each spouse has in terms of assets and debts, and then we equalize it. And then when we get that final number of 160, then we look at and we talk about, well, how do we now finance this payment? So does this mean that spouse B has to sell something in order to fund the payment to pay spouse A? Is this a matter of RSP rollovers or something along those lines? Okay, so I think I'm doing pretty okay on time. How are we doing, Niru?
You're doing amazing on time. You have some extra time. Did you want to go back over any of one of the slides, or do you want me to just go ahead with questions?
Sure, I'm going to skip back to the spousal support piece. Something that I didn't really quite get into is how the payments and the tax consequences that are tied to which payment option that people elect for spousal support to occur. So if it's spousal support payable on a periodic basis, so if it's a monthly amount, let's say $3,000 a month payable by spouse A to spouse B, spouse B being the recipient, that $3,000 is actually taxable as income to her. So when she receives this money, it would be prudent for her to set aside some money from that amount for income tax purposes, because she will have to pay income tax on that when she has to file for income taxes. And the same amount, $3,000 from the payor, so spouse A in this particular instance, it's tax deductible to this person. So meaning that they can take it off from their income. So it's a little bit of a benefit to the person who is paying for spousal support. Spousal support is different than child support because child support is not taxable at all for either the recipient or the payor. Now, coming back to spousal support on the lump sum option. So let's say if spouse A decides to, instead of paying a monthly amount, spouse A is going to give 100,000 to spouse B as a lump sum spousal amount. So once that money is paid, spousal support ends forever. And so the lump sum amount is attractive in the sense that there are no taxable consequences for the recipient. So then the support recipient in this particular method does not have to pay income tax on that $100,000. The downside of it obviously is that, if it's a larger amount, sometimes it's harder for the payor to be able to finance that lump sum going directly to the recipient. The benefit, though, again, of the lump sum versus the monthly amount is that once the lump sum is paid, like I said before, and presumably there is a separation agreement or there is a court order in place that says this, but the presumption is that once that amount is paid, spousal support is closed forever. Whereas with the periodic payment, if you're paying, let's say the two people have agreed that spousal support will be payable for 5 years at $3,000. And so within this 5-year period, let's say spouse B, who is the recipient, becomes disabled, through regardless of, whether spouse A had any involvement to it, spouse B becomes disabled. Now she has a greater financial need because spousal support is still an ongoing issue. It's still a live issue. There is a possibility that spouse B can reopen this issue to extend the timeline, or also potentially to increase the amount payable by spouse A because of her disability, his or her disability. And so that's potentially the downside of the periodic piece, because spousal support can potentially continue even if you have set an end date to it. And let me see here. Yeah, so I think that covers most of what I've wanted to talk about today. So again, this is very high level things I've talked about today. Family law, there's no straightforward answer, unfortunately. It's always subject to whatever your circumstances are. It's never there's never any really a time where it's going to be a cookie cutter answer in terms of, what solution would work for you. And so I would encourage, all of you who are thinking about ending a relationship or is currently going through something like this, that if you haven't already, speak with a family law lawyer, get information before you make major decisions about, what you decide to do with the kids' schedules, with what you are willing to accept for spousal support, and also, what the property division piece might look like.
Mm-hmm. I agree 100% with what you're saying. And I'd have to speak from my own experience, everybody, not my own personal experience. I've been very lucky in marriage, but working in the social services space and working within finance, running into many individuals that are now separated, but during that time they didn't get their finances looked over. They didn't look at the options correctly. A lot of pieces got mixed. So thank you so much for covering it so thoroughly, because it's so true. Those spousal agreements, and if I can add, is when children start to go to college, a lot of people have agreements ending at 18, 19, but sometimes that support is still necessary into the later years, especially if children are going to be going to college and still living with one of the parents, or if they're going to be going to college and RESPs weren't put in, and there's a whole thing that goes into it. But definitely this is not my webinar. This is Jaina's webinar to discuss it. But speak to a financial professional. It doesn't have to be me. Speak to a lawyer. A lot of the information that's required just to find out and put yourself in a good position, because I am running into, especially a lot of single moms, where there was amicable divorces, but things got mixed and they didn't figure out what they needed to do exactly at that time. That's what lawyers are there for, are there to foresee what may happen. So you guys are really, really good at that, because I guess you guys see it a lot. And another thing I wanted to mention is change your beneficiaries on your that's so important, not only to change your will but also to change the physical beneficiaries on your wills. And if you're looking at getting remarried, add your new spouse on, or 50-50 it, however you want to do it. Your beneficiary will trump the wills, and then one spouse has to take another spouse to court, or say, for example, you left it to a family member, you got remarried and you got into a new relationship. So I've seen it a few times. It happened in our counseling office. So that definitely does happen. But getting to some of our questions that we had from our audience, so there was a question that came to me directly. So if I am thinking of separating, what would be the first steps?
That's a good question. So again, I think the first steps would be to speak with a family law lawyer about your particular circumstances, and your lawyer can help you, either potentially craft an exit strategy, especially if there's potential domestic violence issues that are involved. And also, like, at the end of the day, for me, it all comes back to information is power, right? So know what things might look like if you were to separate. And it's not by any means, like, none of us in the family law lawyer community, we're not here actively encouraging people to separate from their spouses in order to enrich our bottom lines, right? We want, if people are able to work it out, like, we're happy to refer you to marriage counselors to see if the relationship can be salvaged. But again, like I've tried to say throughout my presentation today, speak with a family law lawyer. A lot of us offer free initial consultations, get information, find out what applies to you, what's important for you, and then take that away, give it some thought, and then make decisions for yourself from that time. Or, like, and speak with other important people in your life that you trust before making those decisions for yourself.
Mm-hmm. And a question about asset division. So if sorry, I'm just going to make sure you got this right. So if question is, if I'm separating and my spouse, so there's one child, and it's a very specific question. I'm actually going to ask them to call you, but I will say it out. So they're wondering if they have access to the grandchild would still have access to the inheritance coming from grandparents.
That is an interesting question, because it depends on the grandparents, actually, in this case, and what they decide to put in their wills, right? So if the grandparents decide to disinherit a grandchild because of all of this, I mean, technically speaking, the grandparents don't technically have a financial obligation to the grandchild unless there is a history of financial support provided by the grandparent to the grandchild. So if the grandchild is not a dependent on the grandparent, technically speaking, there's nothing requiring the grandparent to have the grandchild as a beneficiary. And so that's sort of, I would say, that is my overarching answer. But it also, again, like, it does depend on the family structure and what's happened in the past, and who's paid for what, and who's provided care for the grandchild, and all of that. So
especially for there's special needs. Every situation is so unique. I'm going to urge everybody to reach out directly to Jaina and discuss those things, because there's very, very specific answers to specific situations, and it's rendering so many factors. There's no cookie cutter approach. Although we have some clues on numbers, the numbers don't always work the exact same way either. So other question is, Right, some very specific questions. So the other question is in terms of custody. So when there's separation and there's relationship breakdown, is family members, that spent a lot of time with the children, are they given any weight in the custody process, or are given some time? Especially, I guess it would be more geared to grandparents.
So grandparents can bring a claim in family court for time with the grandchild if they can show that they've been completely cut out. So it comes down to sort of the specific circumstances of the particular issue. So I will say, generally speaking, yes, grandparents can bring a claim to, have some time with the grandchild, but generally speaking, the expectation is that, if the grandchild is spending time with both parents, that when child is with parent A, then it would be incumbent on parent A to facilitate time with the child with parent A's parents, so grandparents, and vice versa, sort of on both sides, right? So where I would say the grandparents may need to or want to bring an application is if there's very limited time that one parent has, or maybe one parent does not have time at all with the child, and the parent that does not have any time with the child, his or her parents still want to have contact with the child, and the other parent is refusing it, then I would say there's more of a possibility of a claim there.
Definitely. And definitely that does end up happening. That's something we used to see at our counseling office quite a bit, is where there was the arguments between one family being shut out, and the other family, having more access than the others. So it does become a contentious issue. Best always is to try to look at it amicably. The longer you spend in court, it does affect the children. It affects every family member involved. So I think everybody these days knows somebody who is going through a separation, or has gone through a separation and the divorce process. So amicable is always good. So I'd like to ask, what are the best ways to amicably go through the process, the separation and divorce process, and how have you seen it best situated?
Yeah, so I would say the best ways would be to either negotiate through themselves or through the lawyers, or to try mediation first before going through the more time-consuming and more cost-burden options of arbitration in court. In terms of what I recommend, like it really does come down to how the two people are able to communicate, even if they're not able to speak directly to each other, because every time they talk to each other they get into a huge fight. It doesn't preclude them from coming to an agreement using third parties, so third parties being their lawyers or through a mediator, right? So just because they can't talk to each other, it doesn't mean that this excludes them from being able to come to an agreement outside of court. Like, it's a matter of, if it's lawyers involved, then the lawyers would be the ones to help them, craft the message, or to try to remove as much of the emotional piece from it, and to focus on, okay, we have kids that are involved, so we really need to figure out now what the time sharing schedule is, what's in the kids' best interest, because that's always the first and foremost most important thing, and then what the financial pieces look like as it relates to everything else, and how do we make this a situation that no one is ever 100% happy about, but that everybody can live with.
Definitely. I love the answer on that. Taking some of the emotions out of it. And you guys definitely help with that. If you're really emotionally involved in a situation, oftentimes it's hard to be objective. And that's why you have people like Jaina who are especially trained in this, that take the emotion out for you, and they can be objective and they can really identify your needs and possible future needs. And that's what you guys really factor in when individuals that are really emotionally involved are unable to factor in. Definitely, definitely. I once in our counseling office, there's a gentleman that came in, and when I, and they spent $300,000 in litigation, and it actually required the sale of a home. They had multiple properties. It required a sale of a property to pay for the lawyers, and then they had to divide a lot of assets. So and after that, the spouse just wouldn't adhere to the rules made by the court. What would be the situation? What would be the next steps if somebody is just not adhering?
So that's a great question. Before I jump into this question, though, I wanted to go on your point and the emotion piece. That's why I keep talking about the counselor piece, right? So, for someone going through a separation, this is obviously a huge, huge change in their lives. So instead of spending time with me and unloading your emotions on me, and not that I'm not here to hear you out, I'm not trained by my profession to help you work through your emotional issues. So that's why I keep talking about people should really seek counseling for themselves, or as a couple, counseling for themselves, because instead of paying your lawyer however much per hour, and we can't really help you with dealing with the emotional side of things. We can help you craft the message, we can help you with dealing with the legal side of things, but we're not trained to help you on the emotional side of things. So why not pay a therapist, who are usually cost less than we do, and sometimes is subsidized by health coverage? Speak with your therapist, work that out on that end, save money on your lawyer side, so that in terms of discussions with me as your lawyer, we are able to focus on, okay, this is what we need to figure out now, these are the outstanding issues, and that this is the offer that we're going to put forward to try and resolve this. And yeah, so I just really wanted to touch on that piece, because a lot of times, I speak with people who are fresh off a separation, emotions are super high. And again, I'm here to talk to you, I'm here to listen. But at the end of the day, your money is better spent talking to a therapist about working through the emotional piece of it, than talking with me and spending your money on me, on someone who can't really help you through all of that. But also, sorry, so I just had to plug that in there. Nero, back to your original question. So for someone who won't adhere to court orders, unfortunately, for circumstances like that, it's a matter of bringing it back to court for enforcement. Mm-hmm. and potentially for some sort of sanction, again, depending on what the issues are. Mm-hmm. So, if things have broken down to that way, if someone has become so unreasonable, unfortunately, sometimes court is the only answer.
Definitely is. And going back to that emotional point, for individuals who are using legal aid services in their communities, and counseling, they think is not a possibility. There are free counseling services in every community, and there are a lot of online services. Public Allies runs a free support service as well. So contact us right now. We just finished up our last rendition. We actually had nobody really come forward, so we didn't really run it. So we normally do run them. We're going to start again in January. So if you are looking for support, reach out to us. We do run all women's groups, but men also suffer in relationships as well. And it's good to talk about it, because if you don't talk about it, oftentimes we hear about something called psychosomatic symptoms. That's when your emotions become physical health issues. So if you are, dealing with a lot of anxiety, a lot of stomach issues, a lot of other health issues, a lot of it could be provoked by stress from going through situations like this. So seek out some assistance. We definitely will be adding in some resources. And thank you, Jaina. I think I have a few more questions, but I think what we're going to do is going to ask those people to actually reach out to you and speak with you personally and ask those questions. Everybody, don't be afraid to reach out. I know my dad always says one thing: it doesn't cost any money to ask a question. I definitely tell you, it doesn't cost any money to ask a question, to figure out where you need to be to get that assistance. Reach out, get some assistance from us, get some assistance from Jaina or somebody out there who will be able to help you, and not just provide a unsolicited opinion. This is going to be actual help. So thank you again, Jaina. We always enjoy having you on, and we thank you so very much for coming on every time we ask you and providing us with so much information and taking out your evening to give us that time to assist us. So thank you again, Jaina.
Thank you so much for having me, Niru.
Hey, thank you, everybody. Bye. Have a great evening.
Bye.